Hello and greetings again from the Permanent Bureau in The Hague. We're the HCCH. Today you're joining a live panel. We have a bunch of experts with us who will be discussing the private international law aspects surrounding central bank digital currencies. If I may, I'll just introduce the panelists to you. We're very excited to have them with us today. We have Dr. Emily Lee, who is director of the Asian Institute of International Financial Law, the AIIFL, who is also associate professor at the Faculty of Law at the University of Hong Kong. Her research interests are in the field of financial law, fintech regulations and policy, corporate insolvency law, cross-border insolvency law, and comparative law. Joining me in the studio, we have Juliano Alves Pinto. Welcome, a career diplomat since 2007, who is currently the head of the International Legal Cooperation Division at Brazil's Ministry of Foreign Affairs. He was for almost 3 years the Undersecretary for Science, Technology and Innovation, as well as the Undersecretary for Economic Development of the Brazilian state of Minas Gerais. With over 12 years of experience abroad, having worked in 20 different countries, Juliano has been dedicated since 2013 to innovation diplomacy, considered as a pioneer in his own country in this field. Joining us as well, we have Mr. John Ho. John Ho is the Global Head of Legal Financial Markets for Standard Chartered Bank. He oversees and provides legal advisory, transactional and documentation support for financial markets businesses globally for Standard Chartered Bank, its branches and its affiliates. John Ho is on the Financial Stability Board's task force on the legal, regulatory and supervisory frameworks and the FIA Asia Pacific Advisory Board. Joining me as well in the studio, we have Josué Liévano, who is an attorney and a diplomat, and he works as Minister Counsellor for the Embassy of El Salvador here in The Hague, the Netherlands. Previously, he was head of the legal department of one of Latin America's biggest software companies. He has an academic background in law and economics and over 10 years of experience as general counsel for multinational corporations. He currently works alongside international organizations in The Hague as a Salvadoran diplomat. Joining us online from Indonesia, we have Professor Priskila Penasthika, who is an assistant professor in private international law at the Faculty of Law, Universitas, Indonesia. She earned her bachelor's and master's degrees in law, majoring in private international law from Universitas Indonesia, and her current research covers private international law aspects of personal data protection, international sports arbitration, and cross-border commercial litigation. Now, we are here today because of this wonderful project that we have at the HCCH, and we call it the CBDCs project. The CBDCs project received its mandate from the Council on General Affairs and Policy of the HCCH this past March in 2023. And the idea was to have an exploratory study on the private international law aspects surrounding central bank digital currencies. Now, this project as well included a mandate to conduct a colloquium, which is what we're doing today. And the colloquium is to then have subject matter experts identified to the HCCH by its members, as well as by the Permanent Bureau, to give us their insights and expertise into these issues surrounding what is now one of the biggest projects that we see globally. In fact, at last count, more than 91% of global gross domestic products belonged to jurisdictions which are either piloting or already have in circulation central bank digital currencies. We had a kickoff meeting of this project this past July, and an iterated scope paper was sent out for our experts to respond to. We also had a call for videos, and you would, if you had been with us since this morning, you would have heard some of those pre-recorded videos with the inputs of these wonderful experts from across the world. Now, this live panel today will look at those responses and also, of course, gather some more expertise from the people in the room and online with us. And we'll, of course, then talk this through and see what we can come through at the end of this conversation in relation to the private international law aspects of central bank digital currencies. Now, if I may, let's just jump right into that. I think you've had enough of me speaking, and let's go directly to John. John, initial reports from the International Monetary Fund tell us that the vast majority of the world's GDP are from jurisdictions piloting, considering, or even rolling out CBDC systems. Now, in your role from industry as head of legal financial markets at Standard Chartered Bank, from that perspective, what are the most significant developments that we are seeing in the CBDC space in the banking sector?
Sure. Thanks, Gérardine. Thanks for having us. Thank you, everybody. I think one of the sort of most interesting development before I answer the question is to ask the reason why are central banks looking at central bank digital currency. I think to answer the question, I think it's important to understand the backdrop, that what's driving the interest of more than 90% of central banks either trialing, researching, or even launching some sort of a proof of concept in terms of CBDC. I think the against this backdrop, the why is as a result of COVID is sort of accelerated the decline in the use of cash globally. So statistics have shown ever since COVID, a number of people have been forced or moved towards digital payment, contactless payment, and against that, we're seeing an increased usage in contactless and digital payment. We also have seen an acceleration in the use of sort of privately placed, non-central bank issued sort of currency, like for example, cryptocurrencies, stable coins, and these new forms of private money obviously pose in some central banks to challenge the sovereign monetary sovereignty of the central bank. And I think one of the things that is important, if you look at why central banks are doing it, I think in terms of driving this sort of development, is there's a realization that money, in order for central banks to stay relevant, need not only stay where it is in banknotes or coins. Central banks realize that in a digitalized world, you need a digital form of central bank money. So why is it important? The justification of that is there's a central role for central bank to have a digital form of money as a monetary anchor. And I think the distinction factor and sort of key points is that a CBDC, which is a digital form of centralized money, forms an anchor for commercial bank deposits, and it guarantees its convertibility into central bank money. It also forms an anchor to maintain national currency as a unit of account. Thirdly, it's also an anchor to maintain a central bank's control over the financial system. I think if you contrast that with privately issued cryptocurrencies, as history have shown, they don't normally maintain its value as what we call singleness of money. So I think given the fact that increasingly we are in a digitized economy, there's a realization that CBDC plays a huge role in this.
Fantastic. Thank you so much, John. I think that was a wonderful overview and introduction into why we're even looking at this topic. Before we leave you, perhaps in your opinion, what impact do you think this would have on individuals? So you mentioned the digitization of the global economy, now really contactless and digital payments. So what impact do you think this would have really on individuals, so citizens in the world, or business operators conducting cross-border transactions or transacting in, say, cross-border assets?
Yeah, I think if you look at CBDC at this point in time, one of the sort of key challenges is to tackle the problem with respect to cross-border payment. So G20 have identified cross-border payment as a key priority because at the moment the system is opaque, it's slow, it's expensive, and more importantly, it doesn't operate on a 24/7 basis, meaning that especially on a weekend for high-value payments, you got to wait a number of days in some countries before you either make payment or receive payment. So I think with realization that if you want to oil a digitalized economy, you need a well-functioning real-time payment system. And I think a CBDC, where it enables cross-border payment, if it's well-designed, has the ability to facilitate 24/7 payment, instant payment, lowering the costs of transaction, and also foster financial inclusion, especially in markets, emerging markets that largely still have an unbanked and underserved economy. So if you look at some of the stats with respect to the CBDCs that's issued by four of the countries, like for example, Nigeria, Jamaica, the Caribbean, Eastern Caribbean, and the Bahamas, one of the sort of proposition is about financial inclusion because not everybody have a bank account. So the ability to do that would help in terms of facilitate payment. Now, from a cross-border perspective, at scale, we have not yet seen a well-designed sort of CBDC, but I understand that a number of central banks are working towards a number of platform to provide what we call a cross-border payment, precisely to address some of the pain points I just mentioned.
Fantastic, John. Thank you so much. I think you're absolutely right. And in particular, I really very much appreciate your emphasis on financial inclusion and talking also about the unbanked and really getting more people involved in the economy that's really democratized access to finance. And maybe from there, we can look at a more say, a concrete example of a CBDC that's just recently been adopted. And of course, that will bring us into Juliano here in the studio. Now, Juliano, Brazil has been exploring CBDC since 2017 or so and developed its own CBDC, which was very recently launched and is called the Drex. Now, I understand the Drex is intended to operate alongside PIX, which is also a digital payment system platform. And also Drex will circulate alongside circulating paper and coin reals. Perhaps you could give us a quick overview of Brazil's experience from 2017 to today in conceptualizing, testing, and piloting Drex.
Thank you, Jerry. Greetings to everyone online. Greetings to Josué right beside me. It's really a pleasure to be here, and especially to talk about this remarkable experience that Brazil has had over the past years. PIX, as for those who were not familiar with this electronic payment system Brazil launched, started developing in 2017, but launched, as a matter of fact, in 2019, shortly before the pandemic. It has become today the #1 payment system in Brazil altogether. And why did it happen, right? And this somehow reflects upon John's remarks about how the pandemic was important for, let's say, for countries to catch up with technology. And PIX was a means that was devised to make, let's say, payments more universal to people. And PIX is very compelling because it's also for free. So what is needed is just to have a very simple bank account accessible to everyone in the country. Of course, it's operated by electronic banking platforms, individual ones. So each bank has its own electronic banking platform, and the person is able to access its PIX token through those platforms, and the payment is done instantaneously. So there's no need to pay extra money for that. There's no need to wait for the money to be into someone else's account. And it has democratized payments to most people in Brazil, which is why, as I said, became #1 payment mode in Brazil today. And Drex is a step forward because if on one hand PIX was able to universalize payments, Drex is going to bring about access to investments, to credit, to loans, and especially those more sensitive purchases, such as real estate or buying a car, in which you need, let's say, a more secure way to make a transaction. And Drex is going to make sure that you're able to transfer money and, of course, secure your transaction in a way that your car or your house or your piece of land is actually yours in the end. So there's no need for a lawyer. There's no need for a real estate agent in between. So what Drex is, most importantly, is current. It's just an electronic currency. It's just an electronic representation of the actual real, right? And it's not an asset. And it's important to highlight that Brazil has a virtual assets law that excludes CBDCs for the, let's say, of the role of the list of virtual assets, digital assets, and being an electronic representation of the actual real, it works more like a wallet that works inside a specific digital ledger technology, like a blockchain, to put it, let's say, more simply. And with that specific access to it, you're able to perform those transactions apart from payments, so being able to invest, being able to access credit, loans, and et cetera.
Thank you so much. I think it's quite interesting to actually also link the operation of Drex to the policy, the economic and strategic initiatives of the Brazilian government there. You've talked to us about the access to finance, access to credit and loans as well. I think something might be quite interesting, might then turn that actually to your neighbor, Josué. Now, El Salvador is one jurisdiction that's taken a different approach than Brazil. So instead of piloting a central bank digital currency, what El Salvador has done is become one of the first and one of the very few still jurisdictions who have adopted a cryptocurrency as legal tender. Could you perhaps give us an overview of El Salvador's considerations and the experience in adopting Bitcoin as legal tender?
Yes, well, thank you, Jerry. Good evening and good morning to everyone, depending on where you are in the world. Thank you for the greetings also to Juliano. Yes, I would really like to get into it. Our experience has actually been quite fruitful. From a public standpoint, the FDI that having crypto has generated is very big. Like you can see it when you visit the country. You can go to a local store and you can pay or receive payments without having to open a bank account, which brings back to the point of financial inclusion. The FDI that it has generated of like operators that work with Bitcoin has been very big since they come to the country, they install themselves, and they can provide services to other people. And the fact that you have this legal tender, it allows you to make purchases or to make transactions easily. That, of course, has boosted tourism, which is one of the things that the current government is really moving forward to. And you can see it in the beaches. Like, for example, we have this place called Surf City, and it wasn't imposed. It was actually very interesting how the dynamics of like people themselves, like everyone started creating this whole infrastructure of paying and buying through Bitcoin and crypto, and it just happened naturally. So the experience has been actually quite fruitful, like I mentioned before. And I would like to also stress that the fact that it came before COVID was a very good experience. You know, like we are not currently under a CBDC program, but you know, it's always like the stance of the government currently is innovation, digitalization. We have this 10-year plan of digitalizing the whole public sector, and this is part of the whole program and the whole vision that the current government is having.
Quite quickly to follow on from that then, Josué, would the adoption of Bitcoin as legal tender have any impact on the El Salvadoran government's perspective on actually rolling out its own CBDC, do you think?
Well, those are things that, you know, are still under consideration. Obviously, the innovative vision that the current government has is alongside seeing how the experience evolves. So yeah, it's under consideration. It should be like something looked into in the future.
Thank you. John, perhaps coming back to you and ping-ponging back for a brief industry view on this, would it have an impact on the banking sector as to whether countries decide to adopt CBDCs or whether they decide to adopt cryptocurrency as legal tender in relation specifically to cross-border transactions? And if there is an impact at all, in your opinion, what would that be?
Yeah, I think when we look at designing CBDC, one of the key considerations where policymakers, central banks are looking at what are they trying to address, because I think CBDC, as I mentioned, can enhance monetary sovereignty by providing central bank with increased control over the monetary system, effective tools. But at the same time, you know, if the CBD is not well designed, it could also sort of accelerate as what we call a digital bank run, because when monies can move so quickly in the times of stress, it might just make the financial system more sort of under more stress scenario, and the concern of a bank run is very real. But I think what we are seeing in the 4 jurisdictions that are issuing CBDC, they are not proposing a direct issuance by the central banks. Banks still play a role in what we call a 2-tier model, i.e. the central bank issues the digital currency, banks then distribute it to the public. The banks still involved in between to do KYC, AML. So in that respect, the sort of fear is addressed. But at the same time, for some of the smaller economies, when we look at the CBDC for cross-border payment, is the concern of de-dollarization risk, because dollar remains the dominant currency in the international system. In some of the sort of small emerging markets, the concern that they have a cross-border CBDC, for example, a dollar CBDC, and then people might tend to hold dollars as opposed to holding a local currency. So I think there is that concern about whether a foreign CBDC could take over the sort of payment system locally and affect the monetary tools of a local central bank. And I think the other thing to think about is also the geopolitical risk, access to digital payments, and currently, like for example, SWIFT is what we use traditionally. If we have a CBDC that currently circumvents some of the traditional payment system, it could influence countries' choices regarding financial alliances, partnerships, and sort of these are the sort of key consideration one needs to bear in mind. And to your point, whether some countries will adopt cryptocurrencies, as you know, El Salvador have actually tried to do that, but the results is anything but a success, because at the end of the day, as we know, cryptocurrency is not backed by anything, right? It's very much still held as a speculative assets. Do some people believe that because it's scarce, it might go up, but the volatility is too high. So, you know, if your money were to maintain its value, a dollar is a dollar, as opposed to a dollar falls below its stated par. So I do think there's a role for central bank because it's backed by central bank's sort of balance sheet and it's a liability of the central bank. I think that's why, you know, if you look at the projects called Digital Euro, the policymakers are emphasizing that CBDC is risk-free, is central bank's liability, and it's an anchor for monetary payment, and which sets it apart from all other privately issued digital currencies.
Thank you, John. I think we've had actually a very good overview of the policy, economic, and other considerations in relation to CBDCs or the adoption of certain kinds of digital currency, let's say, or cryptocurrency as legal tender. Perhaps to just drill down really into private international law matters and really to look at perhaps even applicable law matters. We turn quickly maybe first to Emily. And Emily, just in relation to the areas of law and regulatory conflicts, could you give us perhaps your insights into the legal implications of adopting CBDCs across borders? What do you think, Emily?
Thank you, Jerry. I think the adoption of central bank digital currencies has the potential to impact various areas of law. Some key areas that may be affected include, there are at least 9 of them. So I'll go through very quickly one by one. The first one is the AML-CFT law, anti-money laundering and combating the financing of terrorism. A very pertinent issue could, I think it would be, would CBDCs be made anonymous to prevent illicit activities such as money laundering and terrorist financing? This might involve updating existing laws or creating new ones, specifically tailored to CBDCs. The second piece of legislation that I can think of is central banking regulation. Central banks are tasked with the mandate to maintain physical stability and B, establish monetary policy. CBDCs could affect how central banks implement monetary policy, including interest rate setting, liquidity provision, and open market operations. The third piece of legislation would be banking law and regulations pertaining to payment systems. CBDCs could have implications for the operation and structure of the banking system and payment systems. In wholesale CBDCs, for example, settlement finality is accomplished via specifically tailored legal agreements between each central bank and its corresponding commercial banks. The fourth is the user protection law. CBDCs may necessitate new consumer protection measures, including data privacy protection rules. The fifth one would be contract law. Questions such as, should retail CBDC be programmable? The use of CBDCs in contracts may require updates to contract law to address issues such as the enforceability of smart contracts, the legal status of CBDCs. Sixth, intellectual property law. CBDCs may involve new technologies such as DLTs, distributed ledger technology, that could raise intellectual property concerns, since the technological design for CBDCs may involve both private and or public entities. This could potentially impact intellectual property and the associated liabilities. Seventh, cybersecurity measures. Cybersecurity measures are implemented to mitigate cyber attacks and other potential threats to the CBDC system. Eighth, tax law. The introduction of CBDCs may require changes in tax laws, particularly in areas related to the taxation of digital assets and cross-border transactions. And the ninth one is the most relevant one to the private international law. We can talk about CBDCs in the context of international law, cross-border issues, and regulatory conflicts. And that leads us to the discussion of regulatory conflicts. To further elaborate on this concept, regulatory conflicts, I'd like to highlight three pieces of legislation. The first one is banking law. For example, what if CBDC become too successful? It is the concern of some central banks, as it might affect the role and function of intermediaries. For instance, if there is a sudden and large scale of conversion of cash into CBDCs, would it affect the bank's reserve? In this case, does central bank have to intervene? The second piece of legislation is the AML-CFT law. Different jurisdictions may adopt different regulatory approaches. For example, there are at least two different approaches that I can think of in this context: the risk-based approach versus the experience-based approach. The first one, the risk-based approach, is the one proposed by the FATF. That is the Financial Action Task Force, the international setter for AML-CFT measures. The second one is the alternative approach, also known as experience-based approach, as suggested by the banking representatives. It is a pertinent issue considering that many banks operating in one jurisdiction, for example, in Hong Kong, have had offices in another jurisdiction, such as UK, US, EU. The differences in adopting or implementing AML-CFT standards will likely result in regulatory conflicts. The third piece of legislation that I would like to further elaborate is the central banking regulation. A model being deliberated in Hong Kong is the so-called CBDC-backed e-money. This CBDC-backed e-money is compatible with the note issuing bank system of Hong Kong. CBDC-backed e-money is private money, i.e. a liability of the issuing intermediary. The central bank's oversight responsibility is to ensure that an intermediary would not overissue e-money without adequate backing of CBDC. And when I spoke of CBDC-backed e-money, is actually a retail CBDC. Another example that I can give you from Hong Kong is the wholesale one, the Enbridge project. The legal advice focused on a few key areas. A, central bank participation. B, the role of platform operator. For example, conceptually, to comply with data governance requirements, each of the central banks could play certain governance roles that the platform will define and agree on. C, AML-CFT, as well as sanctions, to ensure the commercial participant has taken the necessary steps the platform enables transaction-specific certification. And the last one is the one that I alluded to earlier about settlement finality. It seems that the settlement finality is achieved through specifically developed legal agreements between each central bank and its respective commercial banks, the intermediaries. I'm pressed for time, and so this is where I would stop. If you want me to further elaborate, I'll be more than happy to. Thank you, Jerry.
Emily, thank you. That was a very in-depth analysis, and we're very grateful for that. And in fact, instead of letting you off the hook, I have another question to follow up on what you've just told us. I'm just wondering, from your perspective, what are the potential legal implications of including a currency from a non-participating country in a CBDC project? Could you maybe shed some light for us on there?
Yes. I think John mentioned about geopolitical tension, and this is a question that I've been thinking of, because this is a hypothetical yet very plausible scenario for discussion. Involves the inclusion of, say, US dollars in the Bridge project that I just mentioned, which is a wholesale CBDC project collaboratively undertaken by the Hong Kong Monetary Authority, which is the de facto central bank in Hong Kong, the Bank of Thailand, the Central Bank of the UAE, and the Digital Currency Institute of the People's Bank of China. So from a political economy perspective, there might be a situation where one country applies political pressure on another to incorporate its currency into a CBDC project, despite being a non-participating country in that project. For example, US being a non-participating country in the Bridge project. Incorporating a currency from a non-participating country in a CBDC project can introduce several legal implications and challenges. I'd like to give you some examples. For example, the first one, a sovereignty issue and monetary policy. Central banks use monetary policy tools to control their currency supply and maintain economic stability. Including a non-participating country's currency in a CBDC project could affect that country's ability to control its currency and interfere with its sovereignty monetary policy. The second issue would be regulatory compliance concerns. Each country has its own financial regulations, including ML, CFT rules. Including a non-participating country's currency in a CBDC project may raise compliance concerns if the project does not adhere to the regulations of the non-participating country. The third issue is the conflict of laws. Which country's laws will apply in cases of disputes between, for example, intermediary and users, or between intermediaries themselves. Okay, as different legal systems may have different rules governing CBDCs, this could be a cause for concern. The next issue, the fourth one, would be jurisdiction and enforcement. When we speak of jurisdiction, in the context of private international law, we would quickly think of all those different connecting factors, such as A, domicile or residence, B, place of contractual performance, C, choice of law or jurisdiction. So in a complex cross-border dispute involving, say, CBDCs, determining the appropriate jurisdiction and enforcing judgments in such cases can be challenging, because each jurisdiction is likely, each court in the jurisdictions concerned might believe or claim that they have jurisdiction over this dispute. 5. Interoperability, scalability, and standardization, ensuring that CBDC systems can interact with different service providers within existing financial systems and hence developing global standards and protocols for CBDCs interoperability. It will be essential to facilitate cross-border payment transactions and reduce friction between different systems. Addressing these questions and issues is urgent to avoid problems such as A, legal uncertainty, B, foreign shopping, if there are legal or regulatory gaps, C, regulatory arbitrage, and D, increased risks for CBDC users. So to achieve these goals, it will require timely harmonization of legal frameworks and international cooperation. Doing so would help mitigate the above-mentioned risks and ensure a smooth transition towards a digital currency ecosystem. The sixth one is the issue regarding cybersecurity and data privacy, including a non-participating country's currency in a CBDC project might raise concerns about the security and privacy of user data, particularly if the non-participating country has different data protection standards. Seventh, market manipulation and fraud. This may occur if bad actors exploit regulatory gaps or differences between the participating and non-participating countries. To mitigate these potential legal applications, it is essential to establish clear agreements and cooperation between the participating and non-participating countries. Such agreements should address regulatory compliance, conflict of laws, jurisdiction enforcement, and other relevant issues to ensure smooth operation of the CBDC projects and minimize legal risks. So these are the things that I have tried to incorporate in order to echo the first question that I raised about areas of law and potential conflict of interest, conflict of laws, these issues in the context of private international law. Thank you, Jerry.
Thank you very much, Emily. That was a very comprehensive overview of the different conflict of laws issues that could arise. If I might, I'd like to drill down on a couple that you've mentioned, in particular the matter of party autonomy, question of jurisdiction or whether you can contract out of that jurisdiction, choice of law matters, and how that would actually interplay with matters relating to regulatory compliance, for example, KYC, AML type regulation as well. Maybe for that, we can turn to Priskila. I have the privilege of calling her Tita, and I'll do that during this interview. Now, Tita, you've done quite a lot of work on choice of law matters, and of course, party autonomy, as we all know, is an important principle for private international law. Now, in your opinion, would there be any issue in applying, for example, the HCCH 2015 principles on the choice of law in international commercial contracts to transactions where parties agree to transact in CBDCs? What do you think?
Thank you, Jerry, for the question. Thank you as well for having me. As we all know, the legal approach and technical operation of CBDCs vary among countries. So these circumstances will, I think, affect the characteristic of the legal relationship and specifically the contractual relationship with foreign elements that might arise in relation to CBDCs. I believe questions about law governing contractual relationship involving CBDCs have greater relevance in the cross-border use of CBDCs. So if private parties from different jurisdictions enter into a contract with provisions stipulating the use of CBDCs as a means of payment, of course, in the situation that CBDCs are accepted as legal tender, this would then raise issues on the law governing the contract, and the enforcement on of the HCCH 2015 principles on choice of law would potentially be on the table. Another scenario is using the existing digital payment system as platforms for CBDCs as legal tender. Any contractual relation with the providers of the digital payment systems and, of course, the technology providers would definitely entail a discussion on the law governing the contracts. And of course, will lead to the discussion, the use of the 2015 HCCH principles on choice of law. But I also think that choice of law issues might arise in the context of domestic use of CBDCs. So the involvement of international commercial banks as intermediaries of CBDCs in a jurisdiction begs the question of whether choice of law by the parties would be allowed. If it is allowed, the 2015 HCCH principles would definitely have a role to play as well here. Nevertheless, I think it is also important to take into account the dynamics of the development of CBDCs and the various approaches of countries towards CBDCs, given it is a nascent matter and uncertainties remain. For example, the law of the issuing country might have a more important role, thus limiting the possibility of choice of law.
Thanks so much, Tita. I'm assuming as well that the analysis that you just provided us would also apply to other forms of digital assets or currencies, say cryptocurrencies or stable coins. Would that be the case?
Well, to be honest, I would rather be cautious whether the same analysis would also apply to cryptocurrencies or stable coins. What I'm thinking is because the key tenets of cryptocurrencies, stable coins, and other crypto assets are decentralized governance and avoiding the application of any national legal system. So attempting to create an agreement upon a governing law that caters for all dispute between all participants who may be unknown or untraceable to a particular jurisdiction would absolutely be challenging. Moreover, what I also think is, unlike in the two-tier CBDCs, there is no involvement of intermediaries in cryptocurrencies. So the analysis of the possibility of choice of law involving intermediaries that might apply to the two-tier CBDCs that I mentioned earlier may not necessarily apply to cryptocurrencies, stable coins, and other crypto assets. Nevertheless, I observe that the practice of crypto assets trading transactions has shown the involvement of choice of forum and choice of law agreed by the parties. One example that I remember now is the case of Rostami versus Hypernet Incorporation, which was brought before the federal court in California. The plaintiff is a US citizen residing in Puerto Rico. He bought the then undeveloped cryptocurrency tokens known as hyper tokens from the defendant. The defendant itself is a company incorporated in the Cook Islands. So the plaintiff paid a certain amount of Ethereum cryptocurrency tokens. And in the contract, they agreed on the court of the Cook Islands as the choice of forum and the Cook Islands law as the choice of law. So I think in this type of transaction, the HCCH 2015 principles on choice of law would have a role to play as well.
Fantastic. Thank you so much for that. Now, perhaps just pressing it a little further and going back to CBDC questions. In your opinion, Tita, is work on applicable law matters necessary on the cross-border issuance, use, and transfer of CBDCs?
Given the complex legal issues of CBDCs itself, the lack of legal framework on the subject, and the divergence of countries' approaches towards CBDCs, my answer is yes. And
thank you, that's clear.
And exploratory work on this matter would definitely help to shed some light. But of course, the adaptability of the work and any instruments resulting from this work is also paramount, important, given that CBDCs are heavily related to technology, and technology evolves rather swiftly and, if I may say, uncontrollably.
Thank you. So aside from applicable law then, Tita, are there other questions you would pose in relation to private international law issues about CBDCs?
I think echoing to what other experts, including those in the pre-recorded videos, have underlined, the legal characterization of CBDCs is a vital topic to look into. Some literature have argued that when it comes to proprietary issues of digital currencies, the existing private international rules and connecting factors are rather inapplicable.
Thank you very much for that. I think that's quite an interesting overview you've given us, in particular also from the last speakers we've heard, at least in terms of a payment system, there seems to be some economic, strategic, and even legal considerations that perhaps put them into two categories. Here I want to go back to Josué. We heard from John just a little earlier on the success or otherwise of adopting a cryptocurrency as legal tender. And of course, you've heard his opinion in relation to volatility and the use of it and so on. And I'm wondering, because you do have the experience from El Salvador there, perhaps you'd like to kind of enlighten us a little bit on in terms of the experience you've had in El Salvador?
Yes, so thank you, Jerry. The thing is, I think it's very important to realize that when making an assessment about the degree of success of a public policy, especially in an emerging economy or emerging markets as such, it's very important to look that every country may have its different recipe, and the assessment should be made from a grassroots level. And in that sense, I think the experience, I think a way to demonstrate the experience that the country has gone through is when you look at the remittances sector. For instance, our country has, just in the United States, has around 3 million people, which would compose like around a third part of our population, which is living in the United States. So the remittances that come from the United States compose about, say, 22% of our GDP, which is a fundamental part of our economy. Given that remittances can be made through Bitcoin, and Bitcoin being crypto, like going for technology neutrality, going for like crypto or any other type of blockchain, or in which case if CBDCs would apply also, when you have the possibility of transferring funds to another person immediately, and using an infrastructure which is already in place in El Salvador. For instance, we have the Chivo wallet, which is a digital wallet that people can monetize immediately. It's actually very cost efficient, and it's sensed, as I mentioned before, grassroots in the success of the entire project. So the infrastructure is set in place in such a way that it can actually bring about good produce for the people. And going back to your second question that you made before, there is actually also this infrastructure created for digital assets itself. There is a National Commission for Digital Assets, and there is a regulation in place for digital assets. There has been issuance of bonds, and the exploratory part is still underway. I think this is why it's very good to have a discussion of what may entail to go into a project of CBDCs for a country, like the 6 points that were stressed by Emily. I think they're very valid to prove that normative work is very necessary for cross-border transactions, and specifically for DLTs, you know. But although we have the complications of what Priskila was saying before, because many of these are decentralized, and the fact that decentralization is more difficult to control, it doesn't necessarily mean that cannot prove to be successful, though. But yes, normative work, I completely believe that should, and through exploratory work first, like what is being done right now by the HCCH, is necessary.
Thank you so much, Josué. I'm just wondering, maybe we just pop over to Juliano there. What do you think now in terms of a global framework on law applicable or private international law issues and the cross-border issuance and use of CBDCs like Drex, for example, or other forms of digital currencies in Brazil? Then what do you think? I mean, do we need to address these issues? If so, why?
Most definitely, Jerry. And I would agree with what Tita and Emily said about the implication of private international law when we're trying to think about a framework over CBDCs in general. The concept of interoperability is central to understand how we should work within a country's system. And of course, when we think about being able to transfer digital money from one country to another, and somehow it's related to what Josué just said about remittance, for instance, because the cost of transferring money is too high for a person, for instance, who remits money from a country to another on a regular basis, for instance, it's not fair to pay $50 for each transaction as a fee, and that transaction is going to be, let's say, somehow be performed by an intermediate bank, as it usually happens with SWIFT and ABA and all the modes of wire transfers and everything. So if we think about the law applicable to transfer in general from one country to another using CBDCs, and thinking about, of course, interoperability and regulatory conflicts that may come around, if we're able to think carefully about this situation, we're going to be able to, let's say, to foresee a much more internationally integrated economy by going digital for good, enabling countries to transfer resources from one place to another, not only making payments, but also being able to invest, being able to get access to credit, as it is one of the missions of Drex before anything. And going back to the previous question related to regulation, it's important to mention that Brazil has a specific regulatory system on not only virtual assets, digital assets, but also CBDCs, as it is performed by our Securities Exchange Commission, CVM, that we call it in Portuguese, even though the currency, the Real Digital Drex, is issued by the central bank. So there is these two institutions that are, of course, integrated to one another, that perform regulation. And what we're doing right now within a sandbox environment is trying to think about different varieties of smart contracts so that we can attract partners, any sort of partners, through smart contracts, so that we can guarantee interoperability on first more than anything else, so that the platform is, let's say, operational in the end. And since we're going to be able, I believe, within the next year and a half, maybe 2 years, to do so, we can think about something more, let's say, integrated to other countries, because of the experience we're going to have within our own country, which has the right scale to, let's say, to think about something bolder and being able to integrate to other economies. That's why applicable law is so important to think about. And of course, as, let's say, deriving from that, thinking about connecting factors, jurisdiction, enforcement, right? And so that every country should be able, at least every user in a country should be able to, let's say, to use digital real as a CBDC and be able to transfer from one country to another. So that's why it's so important, this project, let's say, to focus on and private international aspects. Thank you.
Thanks, Juliano. I think we've had quite a few responses as well from our experts to the questions that we did put out earlier. In relation to various ongoing projects for CBDCs, for the definition, the design, and the launching of these CBDCs. But now we've also heard, not just in the studio, but also from the input that we've gotten on how important or the impact of digital payments across systems for things like remittances and cross-border commerce, for example. Perhaps I'd like to go back to John. Would you maybe kind of give us a bit of insight there? We've heard from experts here in the studio and from before about the users of these sort of digital payments, and also from our experts, we had a written commentary about how it would be important to provide taxonomy, to bring us all up to date with major CBDC developments. We've even had someone write, and I quote, "The determination of the law applicable is closely linked to the pattern that will be chosen to develop cross-border payments with CBDCs." John, I'm wondering, from an industry perspective, could you walk our audience through what expected significance, if any, the adoption of CBDCs will have on the transfers of funds across borders, which includes cross-border payment systems, but also remittances, for example?
Sure. I think there's a recent study that the sort of CBDs, the cross-border payment issues is about more than $160 billion issue, because if you look at the number of flows out there, that's a huge problem. And as I mentioned, the G20 is very focused right now on making sure that cross-border payment is in terms of cost, in terms of the fact that it is slow, it doesn't operate in a 24/7, is to move in time, in lockstep with increasingly what we call a digitized economy. So to your thing is, what are the things that you know the industry are working on? Is to one, obviously taxonomy, as we talk about. Two is also looking at interoperability. I think the key point is three. We can talk of all the system, but at the end of the day, if different national systems have, you know, different countries have different systems at the moment, not all of them operate the same. You have legacy system, you have new system, especially now some of them are toying with the idea of using a distributed ledger technology. Some of them are obviously looking at new infrastructure. But I think it's important is, regardless of any sort of technology they use, is to have a same standards. When I talk about interoperability, it's not just about technology. It's also about governance standards. It's also about KYC, AML, privacy requirements. It's also about you know, the key tenets that enable cross-border payments. So I think there is a growing need to harmonize the legal framework, to harmonize the governance, to harmonize sort of the messaging standards, such that whatever systems you use, they're compatible, at least interoperable, such that the messaging system or can actually talk to each other. I think that's key. There is obviously a working group right now led by FSB and CPMI to actually tackle this problem, among other things, this interoperability, the standards on looking at how do we remove friction. And I think when we look at friction, it's also looking at legal friction, because there's a study by IMF that to date, if 80% of central banks around the world wants to issue a CBDC, it could not do so because the existing laws does not allow for an existing digital form of money. So there are legislative changes that have to be made, even domestically as well. So I think that's one of the key things to do, is look at reducing the friction, look at what are the impediments towards adoption. The other three things that come to it is also privacy, right? When we move into a CBDC, one of the concerns that people have is, how do I ensure that money behaves like money? But I think, you know, does it still be fully anonymous, or there's a big brother where you know the state will have an ability to track every single movement of money? So I think that issue needs to be addressed. As you know, some countries are looking at it about providing, but beyond a certain threshold, money is like a de minimis amount, is completely anonymous. Some of them will have it with a caveat that if there are suspicious activity, they reserve the right to look at what actually happens, who are the beneficiaries, who are the senders. The other thing is also, how do we fit within the current payment system? And I think one of the things people talk about, and we talk about CBDC, is, are you going to use an account-based system, which is largely what the banking system is? Or are you going to use what we call a tokenized-based system, relying largely on cryptographic technology like distributed ledger technology? Because that is very different. If you adopt a token-based system, there is a study by the IMF looking at the legal consideration. Most countries, the private law at the moment, does not really recognize the token-based CBDC as opposed to account-based CBDC. So they would need to look at legislative reform in some of these countries.
Thank you, John. I think that's a very good introduction into the various different issues that we're facing. And I think it might be also interesting to ask the question, would your analysis have been any different when we're adopting cryptocurrency or stable coins as legal tender? And I ask this in the context of a cross-border payment system. So if we're using this right across the border, and there are private international law issues that arise, there might be some which might be the same, some which are different, perhaps. Would you walk us through what you think?
Yeah, I think the main difference between central bank digital currency and those privately issued currency, the first thing is, as I mentioned, is that the central bank digital currency is a digital form of central bank money. It's backed by the central bank. It is a legal tender in a way that, if you look at some of the four countries that have actually issued it, they make it clear that the digital form of money is actually legal tender. Now, if you look at the privately issued currency right now, bars El Salvador, most countries at this point have not recognized privately issued currencies as a legal tender. They may be money-like, i.e. you could actually use it for payment of goods and services, but they're actually in actual fact not backed by a central bank in the sense that it's not considered a legal tender. That's a main difference, because when we look at the singleness of money, when we look at stable coins with Terra Luna, as the name suggests, although it's supposed to be stable, but we all know in times of stress that stable coin does not necessarily hold its par value. So henceforth, that singleness of money, meaning a dollar means a dollar, does not really translate at all times with respect to privately issued currencies, given the high volatility, given the lack of any intrinsic value.
Thank you, John. I think you raised a particularly interesting question as to a dollar being a dollar and really the singleness, let's say, of these sort of dollarization, is the sort of currencies. Now, from the banking sector's perspective, would CBDCs then be digital assets? I mean, is there a unique legal characterization for CBDCs by virtue of being currency or legal tender? So as lawyers, in the banking sector, how would you look at that?
Yeah, we look at CBDC as a digital form of money. We don't bucket them under digital assets or crypto assets. If you look at some of the treatment under the market in MICA in Europe and also some of the legislation out there, it is very clear that when they look at CBDC is a digital form of central bank money. It is not a digital assets, because that's where they want to differentiate between that. If you look at the prudential standards that BCBS had finalized late last year, they make it very clear when it comes to more punitive capital treatment for crypto assets that are not backed by central bank money, you need to set aside a lot of capital, because given the fact I mentioned high volatility, susceptible to holders could lose the entirety of its entire amount. But when it comes to CBDC, they make it very clear it's carved out from the prudential treatment of crypto assets. So the thinking among policymakers and where we're seeing lawmakers are doing is draw a distinction between CBDC, which is money, albeit in a digital form, as opposed to digital form of crypto assets or digital assets that are backed by either algorithmic stable coins, or in the context of backed by real world assets. But the difference is it's not backed by central bank money, and most, if not all, are not legal tender.
Thank you, John. I think this is quite interesting, because the experts that we've also had on our CBDCs project, they've highlighted how CBDCs, as you said, could be is digital currency, so it could be money, and it could, of course, share characteristics which are similar to, or even some of them which are different than tangible, real, let's say, printed money. Could be one-to-one exchangeable with cash, or could resemble a digital means of payment, maybe something that's adjacent, a near money instrument, but one that doesn't share all the traits of money. So I think what you've given us is a very interesting introduction to this. But you also mentioned the implications of cross-border interoperability. And then maybe I want to go back to Juliano now. With Drex, for example, I mean, what are the implications of such interoperability? Now, assuming that CBDCs differently adopt characteristics of money, depending on different jurisdictions, how would these systems, say a digital payment systems or a token-based CBDC or an account-based one, interact, if at all? And how would you give, say, a non-resident access to the Drex if that would be something in the future?
Yeah, first of all, it's important to mention that Central Bank of Brazil has devised its own DLT, right? So that it enables CBDC to be operational within our system, right? And as I mentioned before, smart contracts being, let's say, tested among different sorts of parties, so that we can guarantee interoperability within our system. Now, if we think about cross-border transactions using CBDCs, as far as I could actually at least check within Brazil's Drex project, we might be able to think about having a main network, which will be our DLT, right? The Drex DLT, and sub-networks that might belong let's say, might be related by agreeing to a certain amount of rules by other countries who might as well, which might as well understand that would be interesting to interact with Brazil's Drex. So the reason why this is important, because of course one of the objectives is to be able to transfer money or make payments at least on a regional basis, in which the actual real, Brazil's currency, is a legal tender already, at least in practice, in countries like Peru, Argentina. And by creating those sub-networks, and of course, being able to consider aspects such as applicable law and jurisdiction, this should be, of course, very well analyzed by whichever countries want to be part of it. But the sub-networks, they need to be established. And as John mentioned, governance is central to that, right? So as long as you have, let's say, the consent from a country, from a country's economy, a country's central bank, to be part of the same network, of course, rules should be established. We can think about maybe in the future, like an authority that would guarantee that governance. Today, of course, it remains with Brazil's central bank. But this is something that we are discussing already, at least on, let's say, thinking about the future, right, as a possibility that will be actually enabled because of the technology that was developed.
Thank you for that. I think that's also quite interesting when we talk about El Salvador's example, for example, when we're looking at, for example, taking Bitcoin or any cryptocurrency, interoperability there doesn't seem to arise as much because Bitcoin is, in that sense, interoperable across the border. What do you think? I mean, the adoption, say, or the designation of certain cryptocurrency like Bitcoin as legal tender, is there a significance there that you can speak to?
Well, I think the important thing right here is, and I think that's where the Bitcoin law is really oriented, is the liberating power of the transaction through, in this case, Bitcoin. Of course, it's private, but the thing is, when it comes to cross-border transaction, the applicable rules will largely depend on party autonomy, like the case that was referred by Priskila recently. So, yes, for this kind of situations, I believe the necessary framework would have to rely on party autonomy. Now, going to the CBDCs case, I believe when it comes to this particular situation, like, you will have to rely on regional agreements, or at least get started from bilateral agreements at the very beginning. And that's why multilateral efforts should be like carried upon to be able to like get all the same standards in terms of privacy, in terms of cybersecurity, in terms of KYC, you know, AML and CFT. So the thing is, when you are able to adapt all these standards, then it's more interoperable. And that's why, like, for instance, if an actor like the EU comes up with a CBDC program that's actually very functional, it sets the pace for many other countries or other regions to be able to like go forward in it.
Fantastic. Thank you, Josué. I'm just wondering, I don't know if John has something else to interject here.
Yeah, I think you know, what I said is, obviously when we look at you know, cross-border side, when we look at applicable law, just to add to that, I think you need, when we say cross-border, you need the other country to recognize the use of CBDC in that, because we you know, if you note that there are a number of CBDC proof of concept that are being launched. For example, the Bank of International Settlement Innovation Hub together with HKMA, Central Bank of UAE, Central Bank of Thailand, and Central Bank of Hong Kong are doing what we call a multi-CBDC bridge, the MCBDC bridge. So that's a proof of concept where we enable for cross-border usage of CBDC. Just a couple of days ago, we also have another report. There is Project Mariana, where the Bank of International Settlement together with Bank de France, Switzerland and Singapore are trialing a cross-border CBDC. But I think what it goes towards, one of the things that being discussed is if to do this, to implement it in practice, you need to ensure that there is a recognition that the CBDC issued by a foreign country is recognized to be used in a foreign country by someone who's obviously like a traveler or merchant. And also that requires a treaty that will also require a reciprocal recognition of each other's CBDC to be used. So I think for any CBDC to be used outside its shores from the home country would require obviously a legislative and treaty to recognize each other currency. So that obviously means that legislative reform may be required, and on a multilateral basis, if countries may have to sign an agreement to recognize it as a legal tender.
Thank you, John. And I think you've given us a pretty good segue into basically the significance of then these differences, and particularly the core questions of private international law. I wonder, Tita, could you maybe give us some insight into what you think about this, and also what's just been said by John, but also Juliano and Josué?
Yeah, thank you, Jerry. Following the discussion on this matter, what I'm thinking this reminds me of this ECNY of Chinese digital CBDC. So if I understand well, China has allowed foreign visitors in its jurisdiction to access ECNY without needing to open a domestic bank account. And again, if I understand correctly, this ECNY owned by foreign visitors in China is not transferable out of Chinese jurisdiction, and I actually do not have sufficient information whether this ECNY is convertible into other forms of central bank money. But in this regard, the first BIL question that came to mind is what law applicable to this legal relationship? Foreign visitors in the Chinese jurisdiction have access to ECNY. And if there is a dispute, what court would have jurisdiction? I assume Chinese law would likely be applicable, and the Chinese court would likely have jurisdiction, given that the only factor that is not related to China in this relationship is the personal status of the foreign visitor. But then again, further question comes to my mind. If there is any dispute, how would it be settled? Assuming that, again, the foreign visitors comes to China only temporarily, his and her or her ID is not easily traceable because his access to ECNY is without any domestic bank account. So I have a lot of questions myself on this matter, Jerry.
Thanks very much, Tita. Perhaps maybe let's drill down a little, and we've already heard mention about the question of intermediaries and how this would work. Now, CBDCs, of course, doesn't implicate a central bank in the sense of you can't go into a central bank with the CBDCs and ask them to fulfill certain kinds of obligations or liabilities. And so CBDCs would, in general, be serviced and implemented through intermediaries. Maybe then perhaps quickly to John, who actually does work for a bank. John, could you speak specifically to the implications of this sort of intermediary arrangements and how private sector intermediaries are anticipated to contribute to this sort of ecosystem or to come into competition with each other and with the public sector? And what are the business considerations of the involvement of both commercial banks and payment companies? What do you think, John?
To the point, if you look at the CBDC that is being in issuance, most of them are adopting what we call a two-tier approach. A two-tier approach is different from the direct model. Direct model means the CBDC is issued by the central bank directly to the ultimate consumer. That is obviously not the model that we've seen in the live deployment of the CBDC in the Bahamas, in Naira in Nigeria, in Jamaica. So they adopt what we call the two-tier approach. The two-tier approach, as I mentioned, is where the CBDC is issued to the sort of participating financial institution. So participating financial institution then will do the KYC, AML, and onboarding of their clients in the ecosystem, where the CBDC is then placed directly to the client. This is the same model with ECNY as well. It's also a two-tier model. And the two-tier model addressed a couple of concerns in the sense that it doesn't disintermediate banks, i.e. banks will still play a relevant role as part of the so-called financial intermediaries. Banks have a trusted role, given that one, they are regulated, they're well capitalized. Two, they do the functions of doing the KYC, doing the due diligence check, AML checks to onboard clients to ensure that's fine. So, and I don't think central banks do have the bandwidth, nor is in their mandate to actually do KYC, AML. So I think one of the things that we should be aware of is that if a CBDC is well designed, like in the context of a two-tier model, and is done in a way that does not crowd out or compete with banks' sort of funding needs, then I do think there is a role for banks to play. And if you look at some of the live issuances, it has shown that banks are able to play a role to sort of facilitate financial inclusion in the case of the Bahamas, Nigeria, and it's without disintermediating the banking system. I hope that makes sense.
John. Thanks, John. I think that's actually quite interesting, and reminds me of a conversation I had with Emily just a while ago in Hong Kong in relation to retail CBDCs. Now obviously, there are also different systems in which they're two-tiered or other kinds of systems. But Emily, I'm wondering, do retail CBDCs have the potential then to impact cross-border payments or payment systems, and maybe also from the view of banks and the banking sector? Could you perhaps walk us through what you think there?
Yes, thank you, Jerry. I have been trying to do a good job in terms of planning my course for fintech regulation. And when I teach CBDCs, when I design the particular lecture, I've been very mindful that CBDCs are put into two different categories, the wholesale one and retail one. The wholesale CBDCs are used by permitted institutions for clearing and settlement. And the retail CBDCs are used by all people and companies, for example, for consumer-to-consumer payments, B2B, business-to-business payment, and consumer-to-business payment. So it's a digital extension of cash. But I realized after reading enough materials that in some cases, these two start to merge. And so that's why I started to think about this question. Do retail central bank digital currencies, i.e. CBDCs, have the potential to impact cross-border payments? And I can find at least two examples. The first example is Project Aurum, which is unique as it could potentially issue both wholesale and retail tokens. According to a BIS expert on CBDC, Project Aurum may serve as a model for global adoption. And I'll give you a little bit background about Project Aurum. It's a collaboration between the BIS Innovation Hub Hong Kong Center and the Hong Kong Monetary Authority. Aurum is a system comprising a wholesale interbank system and the retail e-wallet system. The aim was to bring into life two very different types of tokens, intermediated CBDC and stable coins backed by CBDC in the interbank system. That's why it's unique in the study of CBDC to date. The second example, as alluded to very briefly by John earlier, I believe is also outlined in BIS papers number 120, titled Central Bank Digital Currencies in Africa, because John did mention about Nigeria. In this BIS paper, number 128, the Central Bank of Nigeria, CBN, announces plans to launch the Naira, a retail CBDC. The Central Bank of Nigeria identified several domestic policy goals for the CBDC, including promoting financial inclusion, enhancing the availability of and access to central bank money, and increasing the efficiency and resilience of payment systems. Additionally, and this is my point, the e-Naira aims to improve cross-border payments, even though it's classified as a retail CBDC, and to reduce the cost of remittances to Nigeria. I believe my question is relevant to the HCCH iterated scope paper, question 19. In particular, is it necessary to differentiate between wholesale and retail CBDCs when considering credit transfers? My view is yes, as they serve, they being wholesale CBDCs and retail CBDCs, these two serve very different purposes. The wholesale CBDC is for clearing and settlement. The retail one is for all people to make payments as a digital extension of cash. So I believe that it is a good idea to separate these two, although my emphasis would be these two being wholesale CBDCs and retail CBDCs could, in some cases, as I alluded to and discussed earlier, could merge. These two could merge or be blended together. And so this is the reason why I think this question is pertinent. And I want to thank Jerry for being so accommodating, but I believe for all the three questions that I like to discuss today are very related to the HCCH iterated scope paper, but being pressed for time, I decided that some of the questions can be combined together in order to highlight some of the focuses that we might lose sight. And that's exactly why I put in slightly different version of questions. And thank you again, Jerry, for being so accommodating.
Emily, thank you. It's our privilege to have you. So thank you very much for your insights. Also in actually conglomerating the issues together makes for a much more concise and understandable discussion. So I thank you for that, actually. Perhaps, you've mentioned this wholesale and retail CBDCs as forms of clearing, forms of payment, so really digital payment systems. We've also had maybe some discussion about CBDCs as, as assets, as some sort of proprietary rights instruments. So, for example, we've had one of our experts write to say that CBDCs generally would be treated like other digital assets in relation to considerations around proprietary rights and interests. However, unlike CBDCs, digital assets may not necessarily be money in the sense of money. And there, this particular expert refers to the United States, law or common law in general. And the particular concern is that CBDCs might not benefit from the ability to make transfers with finality or discharge obligations. There might also be some conflicts with the common law take-free rules, the UCC law rules for collateral, for example, in the United States and so on. And so, it's quite interesting because that's quite a common law perspective on this. We've also heard from Juliano just a little while earlier that the Brazilian law on digital assets actually excludes specifically digital asset currencies like the Drex. So it has its own definition of digital assets and very specifically carves out the Drex and digital currencies. I'm just wondering, perhaps you could share with us the main considerations and conclusions here.
Thank you. Matter of fact is we need to consider that Drex, it's a digital representation of Brazil's fiat currency, right? Which makes the value of digital real exactly like an actual real, right? So we're talking about not only a CBDC, but also a platform. The platform is, let's say, it's the key, the most important feature to understand how important it is Drex right now as a step forward from PIX. So being able to make more transactions, not only payments, right? And coming back to your question before, for a person overseas to have access to CBDC, as far as I know, considering that the project's still on sandbox and it has not been launched properly to everyone, and consider the experience we have so far with PIX, a bank account, a Brazilian bank account, will be necessary for anyone to have access to Drex, and of course, a token will enable anyone in the world, since this person might have an account, to have access to its to have access to Brazil's reals DLT in the end. But it's important to highlight that it's not an asset, a proper asset, because it's the fiat currency itself. If we consider fiat currency and legal tender as an asset, of course we can consider that as we have been discussing so far.
Thank you. So by way of just legislative certainty, that was also one of the important things, that the Brazilian law, of course, excludes a fiat currency like a digital currency from its consideration of digital assets, if I understand that correctly.
Yeah, legal certainty in this case is, I think it's the most important takeaway of Drex in the end, because it's going to give people not only access to, let's say, to different varieties of using your own money, but also the traceability factor aligns with a very important law that we have on data protection. This gives a lot of legal certainty, makes any transaction much more secure, and you are still keeping secrecy as part of as the essence of any payment system in the end. And of course, the not having an intermediate bank or any sort of institution, it makes everything much easier and much more cost effective.
Great. Thank you, Juliano. John, from the industry perspective, in considering these proprietary matters, would you say that specific guidance on this particular topic would be helpful on digital currency, so proprietary matters in relation to digital currencies? Now, in your opinion, should the use and transaction of digital currencies include proprietary considerations? And if you could walk us through your thinking, that'd be very helpful.
Yeah, I think it's important, because I think one of the things we earlier talked about is what is money, right? Because I think in many sort of central bank mandate, obviously money is in form of typically banknotes, coins, And I think in the context of when we look at CBDC, particularly when we look at token-based CBDC, it raises very many novel questions, right? So IMF had done a recent study that in most countries, that based on the existing legacy laws, it would token-based CBDC in its current form without legislative changes would not qualify as a currency, because up until now the domain of many of the central bank mandate is limited towards, when you look at currency, limited towards physical banknotes, coins, and bank account. But I think that when we look at a tokenized form of a CBDC, there's also an issue is it legal tender under the applicable law? Second part is, what is the status of CBDC under private law? It's not clear in some of the countries. Whether the legal system attribute this new form of money as currency to be, as equate to money. Thirdly is protections, right? When we look at deposit protection scheme, when we look at payment finality, as we talk about, we need to make sure that money, when you make money, you don't have the issue about concern about, settlement finality. If you look at payment directive, many regulations and many countries, they do say that when you make payments, there is that certainty, legal certainty, recognizing payments that is being made. But with respect to new forms of money, if it doesn't fall within the scope that's currently covered, then there is a question mark. Is it really a currency? Is it treated as money? I think these are sort of legal regulatory issues, and also we probably cross-border private law issues that needs to be addressed before, as a financial intermediary, before we actually can safely adopt it, in a similar fashion as money.
Thanks, John. Now, for our audience, according to the Atlantic Council, 130 countries, representing close to 100% now of global GDP, are exploring a CBDC of some form. Now, with so much attention and developments around CBDCs, it's no surprise that we have different national and regional approaches being developed in parallel. And this, of course, would lead to differences in technical and legal documents. As our panelists have already mentioned, the question of interoperability and how these sorts of projects could basically transmit across a border. How would that help in cross-border payment systems? So perhaps just to close, and mindful of the time, I'm just going to throw a question out to all our panelists here with us today. If you could have blue sky, really thinking of a project within the mandate of the HCCH, which really focuses on applicable law, jurisdiction, recognition and enforcement, of course, with the principle of party autonomy and so on, how would a project, focus on CBDCs, what should it look like in terms of what's urgent, what's timely, what's desirable or feasible, and how would this project be positioned to contribute to the legal framework of CBDCs? I'm going to do something we should never do with a hybrid type panel, which is just to open it to anybody who wants to take the floor at the moment. I don't know if someone would like to try first here in the studio while we see if our online panelists would then also take the floor for that. Blue sky thinking, really in your personal capacities, what kind of project do you think that will go? I have Juliano will save me here. Please go right ahead.
Thank you, Jerry. It's just a very quick comment on the very good question you just posed. And I'd like to echo Josué's remarks on the importance of being grassroots. I mean, each country has its own, features, and they need to be taken into account when enacting a law of virtual assets or CBDCs, and of course, being able to issue a digital currency. So, of course, an instrument such as the one we're thinking about, at least on an analysis level and monitoring and what we could do about it, applicable law, jurisdiction, enforcement, recognition, connecting factors. These are very important, but it's important to bear in mind that we need to cope interoperability with PIL principles, right? So that if we're able to convey something that would be shared, harmonized, considering different aspects, grassroots, as Josué mentioned, of each country's experience, then we're going to be able to make, let's say, international transfers a much easier job. And of course, being able to universalize payments and transactions in a way that before digital, it was actually impossible and and still very expensive, right? So I think we should be able to consider the aspects of interoperability, so technology aspects, and of course, PIL elements. If we're able to do that, at least as a first exercise, and I believe this project has done a great job so far, we're on the right track.
Thank you, Juliano. I'm just going to hop over to your neighbor here because you were mentioned twice. Josué, would you like to add to what Juliano has said?
Yes, and going back to something I also mentioned before, I think when it comes to the negotiation between states for private international law to be applicable, in order for it not to be bilaterally only for their own citizens, I think the mandate of the HCCH is quite on the right path, because I think creating a legal framework that can bring universality and unification of private international law and something that we're seeing that is going to evolve, and it's continuously evolving in different latitudes of the world, especially when the considerations and the legal effects of different jurisdictions qualify the fungibility of a CBDC or of other current forms of currency are different between them, and there's a myriad of different considerations between different jurisdictions. I think the harmonization of the harmonizational work that the HCCH can do within its mandate, it's very important to facilitate the lives of the residents of the member countries.
Thank you very much. Thank you, Josué. I'm just going to go online and see if our panelists there would like to add something. John, would you have something else you'd like to add?
Yeah, just not to repeat what was said, I agree with both gentlemen, but I do think that when we look at the private international law, in order for CBDC to be successful, we also need to look at that alongside some of the key consideration to address What does it mean in the adoption of private international law in respect to privacy? What does it mean in terms of integration to the financial system? And also applicable law, recourse, right? Because the thing is, you know, when we look at central bank digital currency, is it recognized? Obviously, with domestic is fine, but across border, how does it actually work? So working on some of the principles, because like you said, the blue sky means there's ability for cooperation from central banks, public and private sector to work together to reach on a sort of a common set of principles that they could also translate to national laws. But I think we start with the basics, because not all laws are the same, but I think we could work on some very basic principles such that you can actually sort of facilitate in sort of interoperable framework, a governance framework, and hopefully convergence in terms of how they deal with CBDC, especially when we use it on cross-border basis.
Thanks, John. Tita, would you like to add to that?
Yeah, Jerry, not to repeat what the other panelists have said, but and also just to try to be mindful of time here, what I observed that the emergence of CBDCs has shown us that private international indeed goes along with the development of technology. So we can always find private international aspects in almost every occurrence of human life, including technology-related ones. So we are talking about CBDCs here. Echoing what other panels have underlined, the exploratory work that is now being carried out by the HCCH is important and on the right track. It's also urged by Professor Heng Wang that international cooperation on this matter is essential. But of course, I would repeat what I said earlier. The adaptability of the work and an instrument resulting from this work is important, given that this is very technology related. I think that's all that I can say, Jerry. Thank you.
Thanks so much, Tita. And perhaps the last word then to Emily.
Thank you, Jerry. I think CBDCs will likely be used in the future alongside with existing payment methods. For example, the faster payment systems in Hong Kong, which have been used very effectively, and it will be very well used, even with other options such as cryptocurrencies, stable coins. So in terms of interoperability, I think this issue should be taken into account on a broader scale to have all existing payment options in mind, including the things that I mentioned, as well as SWIFT and other options. So that's why I think going forward, there's more work to be done because we don't want to be cornered into either CBDCs or existing payment options. Cryptocurrencies are out there. They are going strong, even though the price fluctuates a lot, but still people are using it. So we cannot deny the facts that they are all being used. And so if this is the case, maybe we should actually broaden the horizon when we take issues at an international level. And so thank you very much, Jerry, for leading such a good project. And I'm very privileged to be part of it. Thank you.
Thank you very much, Emily. And that's our panel, our live panel today. We've been discussing the private international law aspects surrounding central bank digital currencies. And we'd like to thank from the HCCH our wonderful panelists today. We had Emily Lee, Associate Professor Director of the Asian Institute of International Financial Law, the Faculty of Law of the University of Hong Kong. We've had Juliano Alves Pinto here in the studio, the head of the Division for International Legal Cooperation of the Ministry of Foreign Affairs of Brazil. We've also had in the studio Josué Liévano, Minister Counsellor at the Embassy of the Republic of El Salvador here in The Hague in the Netherlands. Online as well, we've had John Ho, Head of Legal and Financial Markets of Standard Chartered Bank. And we've had Assistant Professor Priskila Penasthika, from the University of Indonesia. Thank you to all our panelists and also to our audience for joining us today as we talk about the private international law implications of central bank digital currencies. Now, we're going to take a short break from our streaming. In a little over 5 minutes, we will be in conversation with Professor Caroline Kleiner of the University of Paris as she walks us through a very in-depth analysis on what she considers would be important for the private international law implications of central bank digital currencies. Stay with us. We'll be right back on the half hour. Thank you very much.